Okay, everyone, so while you guys are enjoying your delicious lunch here, I'm gonna get started on the presentation. Does everyone have a copy of the 2-page handout that I brought today? It's just like a cheat sheet, you know. You don't have one? There's extras over here. Okay, Harold's gonna bring them around and pass them out. Yeah, I'm a visual person, so anytime I have something in front of me that I can read, I always learn better than just listening. So I hope this will help you follow along the presentation. So today the topic is going to be about estate planning. And I know a lot of people want to set up their estate planning but haven't gotten around to it yet. So this is a very important topic in today's community because of so many things happening, a lot of deaths that happen suddenly, unexpected events. So even more important to bring this to the forefront. And on top of that, there's actually been a lot of changes in the law too. So I'm gonna go over some of these updates to the law today so you guys can understand what's changing in the estate planning world and why it's so important to get your will, your trust, your power of attorney, and advanced medical directive set up. By show of hands, how many of you do have your estate planning document set up? Okay, great. And how many of you need to get it set up? Okay. Sure.
Which one is more important?
So question, trust and will, which one is more important? So some of these slides here on the first page, it talks about the requirements of a will. And then if you flip to the second page, it will go into the description about a trust. Does anyone know what the difference is between will and a trust? I think that's the most basic question. A lot of people don't understand the basic difference. Yeah, Catherine.
A trust, if you have a trust, you don't have to go through probate.
If you have a trust, you can skip probate. Very true. That's one of the big benefits of having a trust. So yeah, Shan.
You can combine the trust and a will together.
So the question is, can you combine a will and a trust together? Or add a will into a trust? Does anyone know the answer to that question?
Yeah.
Yes? I see no. Someone's saying no, someone's saying yes. So the will and the trust are two completely separate documents. In a typical estate planning binder, where if you guys have estate planning documents, you should keep it in a binder so it's easy to locate. You don't want to be scrambling, when you need to find the documents and can't find it in a pile of papers. So there's usually 4 documents in an estate planning package: will, trust, 2 separate documents, power of attorney, and advanced medical directive. So each of these 4 documents should have a separate tab in your binder, and you should have a copy of these documents to your beneficiaries, to your loved ones, your trustees, so that it's easy for them to locate and know exactly what your wishes are if something were to happen. So big difference between the will and the trust is a will is a piece of document that lists your assets and who you want your assets to go to if something were to happen. Nothing changes right now while you're alive. No assets get transferred, no titles get changed. But with the will, when you pass, that will goes through probate court. Probate court, anytime you have to go through court, you gotta spend money, you gotta spend time, you maybe have to hire an attorney because you don't understand the process. So it's time consuming and expensive. So you wanna avoid probate if at all possible. But with the will, you have to go through probate, and a judge will look at the will, see if there's any disputes, if anyone comes and opposes it. Maybe someone says, oh, you have a will, I have a will too. These 2 wills are different. Then the judge has to decide which will to enforce. So just know with a will, even though it lists out all your assets, all your beneficiaries, it still goes through probate. The advantage of a trust, on the other hand, a trust is a document where title changes now. If you don't wait until death, or something happens, you can transfer your assets into your trust now. So title immediately changes. And then the other difference is with the trust, you have an extra person involved. that person is called the trustee. The trustee manages the trust, manages all your assets for the benefit of your beneficiaries. So when you pass, you have this extra person, the trustee, who can immediately take over all of your operations. They can start writing checks to pay, the mortgage, the rent, any expenses, and it doesn't have to be upon death. It can be if you're sick, if you're disabled, out of the country, just unavailable, the trustee can immediately manage your assets. So you can skip the probate court completely. You don't have to go to a judge, don't have to go through the whole process, and the trustee immediately starts taking care of your affairs. Right? So that's why so many people prefer having a trust in addition to a will. But if you have a trust, you should still have what's called a pour-over will. Does anyone know what a pour-over will is? No? Okay, so pour-over will basically says, if I don't cover something in my trust, everything will go to so-and-so. Because, you write a trust today, but you're supposed to update your estate planning documents every 3 to 4 years. But people get busy, they forget, they prioritize other things. And let's say 5 years goes by, you don't update it. But within those 5 years, let's say you sold a house, you bought a house, you sold a car, you bought a car, you closed the bank account, you opened a new bank account. Well, if your trust isn't updated, then it doesn't cover all these new assets that you acquired. So the pour-over will covers everything you may have forgotten to put into the trust. That way, nothing gets excluded from your estate planning. So even if you have a trust, you still gotta have a pour-over will for all those things you forgot and accidentally left off. All right, so requirements for making a will. In California, and this is state by state, every state has different laws governing estate planning. So today, we're mainly focused on California law. So in California, you have to put it in writing. If you tell someone, hey, when I die, you can have my house, that's not enforceable. So if anyone tells you they're gonna give you something, if it's not in writing, don't take their word for it. It's not enforceable. It has to have a valid signature, and it has to be signed when that person is healthy and of sound mind. If they're signing a will when they're in the hospital, when they're sick, maybe they're not completely all there mentally, it's going to be challenged and it's going to be hard to hold up in court. That's why you got to do it early when you're healthy and not under any pressure and not under any sickness. In California, you also need 2 witnesses minimum. Some states don't require witnesses, but here you have to have 2 mentally competent witnesses. Can't be your kids, can't be minors, preferably not your beneficiaries because there's conflict of interest. So 2 mentally competent witnesses to sign your will along with the person who is signing the will. If you want to revoke a will, it's very easy. You can just rip it up, you can burn it, destroy it, and then it's gone, right? So very easy. But if you can't find your will, some people misplace it, you can write another document and say, this will revoke my previous will. So the will, they look at which one is the later in time. If you have one dated 2020, and then one dated 2022, and then one dated 2024. The 2024 one is going to be the one they look at. All the old ones are gonna be revoked. Does anyone know what intestate succession means? No? So intestate succession, you guys are learning a lot today. Intestate succession means if someone passes without a will or a trust. Do you guys know what happens to your assets if you die today and no estate planning was ever done? Do you know? Go to the country. Okay. Any other answers? Probate. Yeah. But what happens in probate? Let's say it goes to probate. How does the judge decide where the money goes? What is that?
The more closer relative, you know.
The close relatives, but let's say you have 5 siblings, 5 children, your parents, your grandparents, they're all fighting for your properties, they all want the house, they all want the valuable stuff. How does the state know who to give it to?
Go to court.
Yeah, but in court, we're in court right now. So when you're in court and there's no estate planning, if that person is married, legally married, then all the assets goes to the spouse. The kids get nothing, the parents get nothing, the siblings get nothing, everything goes to the spouse. If the person is not married but has children, then everything goes to the children. Okay? And if the person is not married, no children, then everything goes to the parents. And then if no parents, then it goes to the siblings. Yeah, and if no siblings, then it goes to the state. Right? So see how intestate, everything goes to like one group of people, like either kids or parents. It's not like this goes to my spouse, this goes to my kids. There's no separate categorization, right? There's no splitting of the assets. So if you guys want it evenly split, or you want to make sure everyone's taken care of, everyone loves you after you die, then you got to do your will and trust and make sure everyone gets a piece. Otherwise, it's going to go through intestate succession.
But if there's no spouse involved, I guess it goes to the kids equally, right? That's
Yeah.
If there's 2 kids, then everybody gets 1 thing.
Yep. If there's no spouse, then it goes to the kids equally.
And if they're divorced, it doesn't go to the ex.
If they're divorced, they're not a spouse. They have to be legally married. But if they're in the process of getting a divorce and the divorce is not finalized, the wife still gets it. And it.
Companion. You don't marry, but you live together.
So if you live together and you're not legally married and you have no estate planning, the partner gets nothing. Yeah. And so you have to put it in writing. The legally married spouse gets assets. There's no common law marriage in California. That's another big thing everyone should learn. Everyone thinks there's common law marriage in California, which means if you live together for 7 years or 10 years, you're automatically husband and wife. It's a myth. It's not true. Yeah, you have to sign the legal marriage license in order to be legally married. So if you're not legally married with your partner, you better get your estate planning done. Otherwise, your partner gets nothing. And not just they get nothing, they have no say over your medical rights. You know, like let's say you're on a ventilator and your partner knows that you don't want to be kept on a feeding tube for years. They know you want to just die comfortably. But let's say the parents can't let go of their kids. The parents want the kids to keep living on, even if the quality of life sucks. The partner can have zero say to relieve you of your pain and suffering. So, gotta put that in writing. All right, it's very important. If you guys look at slide 15, that's a very important slide. It's the estate tax exemption. Have you guys heard of estate tax exemption? I know Ariana has, Lena has. Yeah, but if you guys haven't heard of the estate tax exemption, basically if you go back to slide 14, there are multiple estate taxes that have to be paid to the government when someone passes. There's federal estate tax, there's state estate tax, there's inheritance tax. The biggest one is the federal estate tax, which if you look at slide 14 is 40%. That means if you give someone $100,000, $40,000 goes to the government and the beneficiaries only get $60,000. But the estate tax exemption gives you this exemption where if it's under a certain amount, you don't need to be taxed. So see how the numbers change so much over the last 9 years, 10 years. So in 2017, that estate tax exemption was about $5.5 million per person. And then 2018, it doubled. And slowly over the years, it's been growing from 11 million all the way to almost 14 million this year. At the end of this year, this is one of the biggest changes in the law. After December 31st, 2025, is going back down to $5 million. Yeah, back down. It's dropping in half. So this is the last year to take advantage of the 13.99 million. And of course, if you don't have $5 million in assets, doesn't matter. Yeah, it doesn't make a difference for you. But if you have more than 5 million in assets and you want to make sure your beneficiaries get it, you got to do an irrevocable trust before the end of the year. Let's say you have $8 million in assets. So 5 million is going to be estate tax exempted no matter what. But the other 3 million, if you don't put it into an irrevocable trust this year, after December 31st, out of the 3 million, 40% goes to the government. And only 60% go to your beneficiaries. But if you put it into an irrevocable trust this year, then your beneficiaries will get 100%. Right? So you want to, this makes a big difference for those who have between 5 million and 14 million in assets.
Did you say irrevocable or revocable?
Irrevocable, yeah.
In 2025?
December 31st, 2025.
Only 1 year.
Only 1 year left. Yeah. Unless, between now and then they change the law again. But as of now, they expect January 1st, 2026 to drop back to 5 million.
Sorry to interrupt, but what if I have a revocable living trust? Will that still protect? Yeah.
So let me move on to the next slide, 16, 17.
Yeah.
Do you guys know the difference between revocable and irrevocable living trusts? Those are the two main trusts. So revocable means I can change it. I can revoke it, I can cancel it, I can edit it, I can put a house in, I can sell it, whatever changes I want. Irrevocable means once you put the assets in, you can't make any changes. It's frozen, right? So, but the irrevocable one is the only one that helps you get the estate tax exemption. The revocable one doesn't give you that benefit because think about it. If you have a revocable one, you put in the property, you get this exemption, and then you take it out later. It's the same, right? You're just taking advantage of a thing that doesn't really change the status of your assets. But if you put it into an irrevocable trust, you can't sell it, you can't take it out. So essentially, the property is no longer yours. So you can take advantage of the estate tax exemption. So it makes sense.
So are there different types of irrevocable trusts? Because I know in life insurance is what's called an IMIC.
eyelid, yeah.
There's got to be different for like properties for real estate.
There's so many different. There's 320 different revocable and irrevocable trusts. Yeah.
If you're still alive, other than the tax exemption, why would someone create irrevocable trust and taxes other than just the tax, no other benefits?
Okay, so the question is, why would you put your property into an irrevocable trust, right?
And why would you create an irrevocable?
Why would you? Yeah, so there's a lot of benefits to the irrevocable trust. So one of the benefits is the estate tax exemption. Another benefit is protecting against lawsuits. Right? So revocable trusts don't protect against lawsuits. So let's say you accidentally hit someone on the street, a pedestrian, and they suffer $1 million, $5 million damages. Your irrevocable trust, they cannot touch anything in the irrevocable trust. But if you don't have the irrevocable trust, you personally are liable. You're not protected by a company or an LLC because you personally hit that pedestrian. They can take all your assets if it's not in an irrevocable trust. They can take the assets in the revocable trust. So that's another benefit. Another benefit is privacy. So if someone goes and searches your name, they can find all the properties in your name, right? Because title reports are public. You just call Lena and she'll give you all the title reports. or Rihanna too. But if someone goes and searches, if someone wants to sue someone, they're gonna go and search to see if they have assets under their name, right? If they don't have assets, why bother suing? You're gonna spend all this attorney fees. If they're bankrupt, you're just wasting your time. So if they go and search your name and all your property is in the trust, and don't use your name for the trust. I know a lot of attorneys and a lot of people like to, put living trust of Elizabeth Yang, living trust of, your own name. There's no privacy there. They know that's your trust. So you should put a trust name that's neutral, like Golden Dragon Trust, or Good Fortune Trust, or something that they can't recognize as your trust. So when they go and search your name, they're like, oh, he or she has no assets. They're bankrupt. I'm not going to sue them. So it protects the rich people. You can, if it's revocable, you can change the name of your trust. If it's irrevocable, it's stuck. But then if it's irrevocable, they can't touch it anyways. So that's okay. Yeah, great questions, everybody. Yeah.
If you leave it to someone specifically, and then let's say you get married, does that husband have anything? I mean,
So irrevocable trust, if you leave it to someone and then you get married, yeah, the irrevocable trust stays. Your marriage, a new child, any life changes, it doesn't change the irrevocable trust. No. Once the irrevocable trust is set, unless when you set it up, you put down later on, if I get married, then it will change, or later on at this year, it will be revoked. You have to set it up at the time. Yeah, but later, if you set it up and you didn't put it in at the time, you can't change it later on. You never can change it. It's just going to go to your beneficiaries when the occurrence happens, whether death or something else happens.
So if your daughter-in-law is with your son and then they get divorced and it's put in the son's name, then the daughter-in-law cannot touch it.
If the daughter-in-law and your son, if they split up, and then you have an irrevocable trust in your son's name, then if the irrevocable trust is just your son and not, she cannot touch it. So that also, so it protects against lawsuits, it protects against divorces. Yeah.
They just get married and don't care.
Right, so if you want to protect your children's assets from your daughter-in-law or son-in-law, you can make sure, like, when you pass your asset to them, you put it in their irrevocable trust, and then it will guarantee to go to your grandchildren. And if they get a divorce, your in-laws cannot touch it. So that's a way to protect against divorces from your kids.
So just the living trust is not irrevocable, right?
Living trust is a revocable trust, so it's not irrevocable. Yeah.
Okay, so revocable doesn't provide asset protection.
Revocable doesn't protect, no asset protection, no protection against lawsuits, and no estate tax exemption.
because in reality, that's not yours no more.
But yeah. In a revocable trust, it's still your property. So there's a little chart on slide 18. I know the slide is small, so it might be a little hard to read.
Just a quick question, follow-up. I mean, is a living trust same as a family trust? Because I've seen both living trust and family trust. Is that the same?
So if you set up a living trust on your own without a wife or kids, then it's not a family trust. So family trust is one where you set it up with the family, whether a spouse, with your kids, everyone puts in the assets together. But so living trust can be a family trust, but not always.
So what if you have a revocable trust? Can you change it at any point in time to be revocable?
Yeah, so if you have a revocable trust, you can change it any time to be irrevocable. But not the other way around. And then you can also have multiple trusts. Some people have let's say they have a home and they know they're going to live in there for the rest of their lives. They're never going to sell it. So they put their primary residence in an irrevocable trust. But let's say they also have investment properties that they might want to sell and invest in other properties. So they'll put their investment properties in revocable trusts. So you don't have to put everything in either a revocable or an irrevocable. You can have many. Yeah, you can have a separate trust for every property you own. I'll get to Oriana's question right after this. I'm almost done with the presentation. So slide 18 is a good chart, like a visual, so you can see the difference between revocable and irrevocable trust. So revocable, there's flexibility, you have control, you have the estate tax. Oh, I think it's running out of battery. And you have protection, there's no protection from creditors. And then irrevocable trust, your terms are locked, so there's no flexibility. You give up total control of your assets. There's no tax on the assets, and you do get protection from creditors. So 4 major differences between revocable and irrevocable trust. There's 2 slides, 19 and 20, about living trust versus testamentary trust and funded versus unfunded. These are just some of the more commonly used types, but like I said, there's hundreds of different types of trust. So living trust is created now when you're alive. Testamentary trust is created when someone passes. So let's say you want to, like what Angie suggested, protect your kids. You can have a living trust for yourself and then a testamentary trust for your kids. So right now, because you're not giving any assets to your kids yet, they don't need a trust yet. But once you pass and then your assets go to them, then you can create the testamentary trust. It occurs upon death. And that will protect your kids against any of their creditors or exes or whoever. So that's the difference between living and testamentary. Funded versus unfunded. You don't need to have property in a trust now in order to open a trust. If you plan on buying a house, if you plan on getting money from your parents or family members, you can open a trust first that's empty, called an unfunded trust, and then later on add the properties into it. And then the final documents I want to go over is the power of attorney and the advanced medical directive. So a power of attorney gives someone the ability to sign documents and do things on your behalf. A lot of people, the biggest myth is that they think a power of attorney will continue to work after the person dies. No, when a person dies, the power of attorney dies with him or her. So no more power of attorney after that. Right, so you can't use a power of attorney to manage assets or anything. It dies with the person. You have to be a trustee in order to manage property after someone dies. And then the final document is the advanced medical directive. This tells your loved ones what you want to do in case of a medical emergency. Some people think they want their doctor to make the decision. They say, oh, I don't want to think about it. I'll have the doctor, the medical professional, take care of it. Medical professionals don't make those decisions. And so many times in the hospitals, you have loved ones ending up fighting over these critical decisions because, they have different opinions. So to help your loved ones not have to go through that suffering, you just make your decision clear cut. So they just follow your wishes and they don't have to make those difficult decisions for you when it's already a challenging time for them. All right, so get this done sooner than later. Don't wait until the last minute. During the pandemic, so many of the potential clients came. They're like, oh, my loved one's in the hospital. We need it done now. Can you come to the hospital, get a notary? Sorry, at the time, like COVID, people can't even go in the hospital. How am I going to get a notary in there? And then you have to have the capacity, mental capacity to sign it. So do it now. If people come too late, attorney's hands are tied. Nothing we can do to help at that time. So, Oriana, you have a question?
Yeah, okay, so we did a revocable trust. What happens when one of us dies? Does it become irrevocable?
No, it's still revocable. It won't become irrevocable until you specifically set up an irrevocable trust. So if it's joint, and let's say like the property goes from you to Tony or vice versa, then at that time you might have to do an updated trust with just one person.
Okay.
Yeah, Catherine.
What about, I have a question, that's kind of something I'm going through right now. What about when the trustee is not following the trust, but the trust was done in Oregon, another state? Do you have to hire an attorney in the other state?
So question is, what happens if the trustee doesn't follow the trust terms? Trustees have fiduciary duties to follow the trust terms. They can't just do things on their own and against what your wishes are. If they do that, then the beneficiaries can take them to court and get the trustee replaced.
Right, but do they have to hire an attorney where the trust was made in another state?
Yes, yeah, they have to do it in the jurisdiction that the probate court is going to take place. For trustees, if you don't have a loved one or a family member or a friend who can act as a trustee, you can also hire corporate trustees, right? There's professionals out there that act as trustees. They take a percentage or they charge a certain amount, but there can always be a trustee you can hire. Yeah, but they have to follow fiduciary duties. And then in your trust, you can also put first trustee, primary trustee, and secondary trustee. So let's say your trustee dies before you and they're no longer there, then you have a secondary trustee. Same thing, you can have primary beneficiaries and secondary beneficiaries because you never know who's gonna pass first, right? So you can always have contingencies.
Without going to all the court, which is costly, I'm sure. You can't do anything about them.
You can ask the trustee to step down, see if they will willingly step down, send a demand letter saying, these are your violations, this is how you didn't follow the trust, you're in breach of fiduciary duties. If you don't step down, we're gonna go to court and replace you and then make you pay for the attorney fees. So usually if they see that they're in violation, they will willingly step down. But if they're unreasonable and they just wanna fight and not step down, then you have to take them to court.
Is there an extra cost involved for switching revocable trust into irrevocable?
Is there a cost to change from revocable to irrevocable? There typically is because you're basically starting a new trust. The irrevocable trust is a brand new trust, different terms, different content. Yeah, and know that the trust or any of these estate planning documents, nothing's filed with the courts, right? They're all just documents you keep in your safe, in your house. No one looks at it until the time comes. Angie.
One more question. Nowadays they say if I own a house that's 500,000 when I buy it, and then I pass away and this house is now 5 million. The real estate lawyers, all the capital gain would be tax-free to inheritors. Is that right?
Well, if it's under 5 million, then that's the estate tax exemption, right? But if you bought it for 5 million, now it's 10 million, then you better put it into the irrevocable trust this year.
One more question. I'm a life insurance agent. Some of my clients are foreign nationals, and a lot of them own single house and 7 figures for multiple houses. I know their tax exemption is only $60,000. What can I help them to protect their assets?
That's a tough one. Yeah. See, we have this 13.99 million exemption, but non-citizens, foreign nationals, they're $60,000 only.
So far, the only solution my boss and I are working on is just purchase extra living life insurance for them, and then dedicate that into a ILIT.
Yes.
And use that to pay for the.
Yeah, that's why a lot of people are buying life insurance policies with ILITs because that's a way to save taxes. Yeah, so talk to her to open a life insurance policy.
If you know someone that doesn't have green card.
Yeah, that's a good solution for foreign nationals. Yeah, Sean.
Question. Let's say my trust got stolen because my house got robbed. So they just took everything from the safety, but we put the trust in the safety box.
Yeah.
So we only have electronic copy in that case. Is that still valid, or you need to have something with a wet signature?
So question, if your trust gets stolen, then, if you only have an electronic copy, is that okay? As long as it has the notary seal, it's okay. And usually your attorney will have a copy too. The attorneys usually keep copies of all the estate planning documents for their clients for 7 years.
For 7 years.
It's for 7 years, because you're supposed to update it every 3 to 4 years. So if you update it, then the 7 years resets.
So when you update it, that's ask my attorney to get a hard copy as well.
Yeah, or you can just contact the attorney anytime to get a copy. But electronic copy is okay. It doesn't have to have a wet signature, as long as it has the signatures and the notary stamp. Yep.
Okay, may I interrupt? It's about time to wrap it up because it's almost 1:30. That's the time we all always return. Maybe one last question?
Okay.
Wrap it up?
Yes.
So what box do I check if I want to take it all with me?
What box do I check if I want to take it all with me?
Okay, let's give her a big hand.
My pleasure. sure.
Give us valuable information.